Hello, hello everyone, and welcome to our McGuireWoods webinar on OFCCP's AAP verification requirements and risks for federal contractors. My name is Bill Doyle. I'm a partner in the labor and employment practice here at McGuireWoods. I'm joined by my partner, Brian Barger, who's also a partner in the labor and employment practice of McGuireWoods. We have a really strong national OFCCP practice that focuses on a broad array of different aspects of OFCCP issues, including and very sophisticated issues involving OFCCP enforcement, OFCCP compliance issues, and OFCCP jurisdiction issues. We have a really broad bench of very experienced OFCCP practitioners at McGuireWoods, in addition to Brian and I. We're here to talk about a new OFCCP compliance requirement. It seems like we've had a flurry of items from the federal government recently here at the tail end of the summer. I just wanted to note that in addition to our strong OFCCP practice, our firm, we're a large firm with over 1,000 attorneys and 26 offices, and we help employers and businesses across a broad array of different practice areas and in different industries. If business has a problem, McGuireWoods has somebody who's got expertise to help on that problem. So if you have any follow-up or needs of any kind, including around these OFCCP requirements that we're going to talk about, please feel free to reach out to us or to your contact at McGuireWoods. Before we dive into our topics today, let me give you a couple of points on our platform. We're recording this presentation, and you'll see some icons on your screen. There's a resources icon that includes a copy of the presentation. So at any time, if you'd like, you're welcome to save the deck to your desktop or print it out to follow along during the presentation. Second, you'll see a question and answer feature. You can use this to submit any questions that you have throughout the webinar, and hopefully we'll have some time to try to answer the questions at the end, which will leave the questions towards the end. But if we don't get to your question, we'll follow up in a separate communication response to you answering your question. So feel free to ask any questions. If you don't want to ask questions through the Q&A, feel free to email Brian or I directly. Our email addresses will be in the slide towards the end here. So where did this come from? It's kind of a unique thing to happen right in the very beginning of a new administration, because you would think they don't have enough time to put in place this kind of verification requirement. And in fact, they didn't put it in place. It was really put in place by OFCCP's political leadership, DOL's political leadership during the Trump administration, which is a little bit unusual because typically in Republican administrations, you wouldn't see this kind of a broad-based requirement that does impose significant burdens on employers. And there is a very large question mark as to the need for this and whether it actually would satisfy OFCCP's enforcement priorities and whether the burden involved is going to be worth the benefit that the agency would get out of this kind of requirement. But in any event, there was a GAO report at the tail end of the political leadership at OFCCP in the Obama administration that covered a bunch of different things that it criticized OFCCP in terms of not being able to enforce broadly. And one of the areas that the GAO report covered was that OFCCP doesn't really have a way to generalize its audit results into a some type of a broader assessment of the likely compliance status of the universe of covered federal contractors, because the way OFCCP conducts audits is not a stratified random sample, and therefore you can't generalize, the results. Typically, when you do want to do something like this, you don't ask for certification of every single covered entity. You would do some kind of sampling approach and then generalize using statistical principles in a sampling. That's kind of the nature of when we do a poll. We don't ask 100 million people how you're going to vote. You ask, 5,000 how you're going to vote, and then you generalize that. And so this is kind of almost like a way to address that issue, but it kind of is a very blunt approach. So the political leadership in the Trump administration issued this directive in 2018, basically saying we're going to study this and we're leaning heavily towards doing this. And the general concerns were that, we don't know what all the, we can only audit a small portion of our jurisdiction, and so we don't know what they're doing. We also have seen contractors have some delay in responding to the scheduling letter. Now, the scheduling letter requires a lot more than what's just in the AP, and the scheduling letter has changed and expanded dramatically in terms of what you have to submit over the last 5 or 7 years. So I don't think these points are very, very compelling reasons why you would have a verification like this. So in any event, towards the tail end of the Trump administration, the agency started to make this operational and sought OMB clearance. They didn't go through notice and comment process to change the regulations to permit this. And we'll talk about that later, but they went through an OMB Paperwork Reduction Act approval process that required notice and comment. They received comments, and they were focused on several issues that were even more alarming than the idea of everybody having to do an annual certification. And one of those ideas was that everybody would actually have to submit every AAP they created to the OFCCP, and that obviously was something that they fortunately chose not to do, but they rejected the idea that it would be done every other year. They said it has to be done every year. They refused to clarify some vague terms that we'll talk about, and they didn't really grant audit relief for larger contractors. There was some hope, and some of the AAP vendors were kind of pushing this in some surprising public comments where they were actually supporting this approach, presumably because that would somewhat drive people to make sure they got AAPs done every year, and then they would get more AAP work out of this type of certification. But also with the idea that maybe that would divert OFCCP's focus on larger workplaces and allow OFCCP to spend more time on smaller or mid-sized employers that might not be actually complying very well, and therefore not subject OFCCP, larger contractors to frequent audits, which has been the case over the last period. We filed comments that were generally recommended against the verification and brought up a lot of problems with it in terms of clarification of vague terms and other issues. You can read our comments. There's a link there that you can access them. So then OFCCP created a new website now in the Biden administration that is not really up and running, but it is it's kind of like a coming attraction. and then there was some period, presumably, where some personnel in OMB were turning over. The new political leadership at OMB had to get on board to look at this and determine, is this something the Biden administration wanted to pull the trigger on? And they ultimately did just a couple weeks ago at the end of August, and that's why we're here talking about this. There's a question about whether the agency has regulatory, authority to do this kind of they went through notice and comment for the Paperwork Reduction Act requirements, but they didn't use rulemaking processes to give themselves clear authority to do this. Instead, they're relying on a ancient regulation that goes back to the 1970s that's actually never been implemented by the agency that allows them to request a program summary. And then they say, yeah, this isn't a program summary, but this is like, we could force you to do a program summary. And since this is so much less burdensome than a program summary, the program summary regulation must be sufficient regulatory justification for doing that. That's dubious reasoning in general, but also dubious in terms of the administrative law framework. It's also dubious to think that you could use a regulation that's been on the books, but basically dead letter for your entire, existence of 40 or more years, and then think that gives you some blanket authority to revive it and do some kind of new thing that is less burdensome. If somebody wanted to bring a regulatory challenge to this, I think there's a prime opportunity to do that if somebody were interested in challenging OFCCP on these grounds. I'll turn it over to Brian to continue the discussion. There's many aspects of this we'll talk about.
Yeah, thank you, Bill. Hello, everybody. This is Brian Barker here in our Charlotte office. To pick up what Bill said, we're going to pivot now and talk a little bit about some of the operational sides of exactly how certification is supposed to function, at least as best we know it. And I'll be honest, the number one question that we're getting, frankly, the number one question I would like to know is, so when does this actually begin? OMB's approved this. We have the outlines about how this is supposed to work, but when does the actual clock tick? And the frustrating thing, frankly, sitting here today is we don't know. And this is sort of amazing, actually, if you actually look at the OMB supporting statement itself and the amendments that they did prior to sort of approval. There's actually two triggering actions that they mention in the statement, but they conflict. Triggering action number one says that existing contractors will have at least 90 days to comply, quote, once it takes effect, and that the effective date will be 90 days after OMB approval. So if that's the case, in theory, the clock is ticking, and we can expect to certify by November the 29th. But then they also go on and say, actually, this is not going to begin until after OSP does email notice to individual contractors, plus post a notice on the agency website. And the theory behind this, I believe, is OSP is going to take your EEO1 data that they have for you and other contractors and subcontractors based on the box that you check on your EEO1 form indicating that you're a contractor. They may take some other data from the federal acquisition system or otherwise, and they're going to try and identify, okay, who do we think should be turning in affirmative action plans? And they're going to send you a notice that says, hey, guess what? Congratulations, you need to certify, or we think you need to certify. But they're going to do more than that. They're also going to post a general notice on the website to try and pick up other individuals who they may not have within that sort of system. If that's the case, and that makes some practical sense, frankly, they're not going to be real keen to do that quickly, in part because, think about it, your EEO1 data is ancient. People have not turned in EEO1 data because of delays authorized for COVID for a couple of years. and the 2019 and 2020 EEO1 Component 1 data is not even due until October the 25th of this year. And so if the idea is to use this data, which we think is the case, to send notices, and as we'll talk about later, pre-populate some of the systems, well, then they're probably going to need to wait to at least process some of that data. And if that's the case, the deadline is probably going to be sometime in 2021. Unfortunately, there's no clarification on this today. We'll talk about this later, and there's no press announcement from OFCCP on this, so we'll just have to watch that space. But if we had to guess, the clock is not ticking, in fact, and it will start to tick maybe later after we see these notice and website postings. So how often will you have to certify? Well, the certification is designed to be annually. As Bill indicated, there was some discussion about whether that was going to be different or whether you're actually going to be doing some filings. There is no filing required. It's going to be an annual sort of certification of some sort. And in as far as the timing of that, though, when will it occur? In the supporting statement, OFCCP indicated that they told OMB that the timing for contractors will be uniform. That means that all of your establishments, no matter where they're located in the United States, if they're covered by the AAP requirement, will all certify at the same time. So you'll go in as a contractor and certify everybody all at once. And likewise, all contractors, assuming they're covered, and other subcontractors will also do that at the same time. What's the problem with that? Well, the problem with that is going back to the regulatory support that Bill mentioned. You think about the program summary. That's not how program summaries work. If you actually look at the program summary language, it talks about how the underlying regulation will be submitted each year on, quote, the anniversary date of the affirmative action program. And that makes some sense, frankly, if you think about it, because everybody gets to pick their own anniversary date. By regulation, you're not required necessarily to pick January 1. A lot of contractors, a lot of our clients, in fact, do not do that. And they'll tie it to their fiscal year or they'll tie it to other things. And that program summary sort of makes a nod to that. But the OMB supporting statement does not. So there's a conflict out of the box with that. Likewise, there's just some practical issues about how they're going to sort of do the timing, in part because if contractors are not required to be uniform, which they're not, and they're going to do a quote of certification requirement, they're going to need to probably give a little bit of wiggle room about the backward-looking effect of the certification. Otherwise, depending on sort of when the deadlines hit and when your actual affirmative action plan anniversary is, you may need to scramble. And so they're probably going to have to issue some clarifications in their final sort of rules on this about how that's going to work. So how will you submit it physically? Well, there's going to be a portal for this. There's actually a web-based portal that Bill mentioned. It's already up. At least the landing page is up, but it's not yet active. And as Bill said, they just tell people it's coming soon. They've also posted, as of the other week, a brand new administrative guide for the verification interface and, quote, the user guide for the verification interface. That is up and available to read, but it's mostly, frankly, a bunch of sort of internet and interface sort of instructions. It doesn't give you a lot of detail about some of the other questions that Bill and I are raising here today and otherwise. But in theory, when you submit this certification, it's not going to be through the SAM system. It's not going to be on your EEO1 report. It's not going to be a mail-in form. It's going to be something that you're going to do based on this web portal guide. So how is it going to actually be submitted itself once you're in it? Well, when you look at the new published guide, it's pretty clear that OSP intends to use your employer's EEO1 data as a base to pre-populate the certification form. So you'll fill out some basic information, put in your EEO1 sort of verification number, and in theory that would populate or pre-populate some of your quote establishments that need to be certified for AAP compliance. And in theory, if you look at the user guide, it says that once you do that, there will be a sort of a separate page, heaven forbid, for every establishment. So in theory, if you've got 150 or 1,000 AAP establishments where you really do sort of have that potentially under your EEO1 reports, there might be a separate page for each and every one of them. Now, this is going to create a lot of issues, and we'll talk more about this in a second, but this creates issues in part because EEO1 establishments and locations don't necessarily line up with how the AAP rules are designed. As you well know, you're not required to have an AAP for every last location. There are roll-up rules for smaller establishments, and so you may have an establishment that's listed in your EEO1 report, but in fact does not have an AAP itself that's freestanding. It's actually rolled into something else. And so how that's going to be addressed, we'll just have to see. Likewise, and Bill's going to talk about this a lot more, there are OFCCP single entity test rules for related legal entities within a family of companies about whether or not there's OFCCP jurisdiction. And what that means, which we'll talk about more, is that you may have within your family of companies on your EEO1 report some entities and locations that are federal contractors and subcontractors, and some for different legal reasons who are in fact not covered, that are outside OFCCP's jurisdiction. But when they pre-populate this form, they're going to pre-populate it for God and everybody. And that's going to create some issues where you're going to have to be very careful about who you're checking the forms for and for what entities. And again, like I said, Bill will talk more about that. But even though it sounds simple, it sounds straightforward, in fact, using this methodology, it's not going to be, in our estimation. So what are you certifying? What's the text? Well, the text itself, you can look in the user guide. It's interesting. It talks about the fact that a covered entity must attest that it is developed and maintained. AAPs, quote, at each establishment, quote, as applicable, or for functional business units if you have a FAB. And then there's some rules for if you are a new qualifying contractor or otherwise that don't have an affirmative action plan as of yet, but you're in the process of developing it. Most people are going to be checking box number 1 if you're an established contractor. And this is somewhat similar to language you may have seen before in the GSA sort of SAM system regarding questions and declarations for individuals who are bidding, but it adds the word maintain. It's not just developed, but that you are, quote, maintaining your AAP. But I'll tell you, the devil's in the details. This is part of the comments that Bill, myself, and others submitted in connection with the OMB sort of comment period. There is no defined term about what developed and maintained actually means. We actually requested OFCCP to get some guidance on this and to tell us a little bit more about exactly what they expect to mean when you click that box. And they expressly declined to do so, which is interesting. The other thing that's interesting, as I mentioned, is the regulations do not, in fact, require an affirmative action plan for, quote, each establishment. Now, they may be getting out of that because of the caveat that you have to certify this for each establishment, comma, as applicable. But again, sort of how that ultimately gets vetted out when they issue final instructions, we'll have to see. But technically, that development maintained language we think is problematic. And frankly, this is more than just a little bit frustrating. It's a matter of just straight up constitutional law. Regulated entities like federal contractors and subcontractors have a due process right to fair notice. And we would argue that undefined terms like developed, could simply mean that you have a document of some ilk in physical or electronic form called an affirmative action plan, and that at the time you certify it, you've got it in hand. And that's all you're certifying. But it can be more, right? It can suggest that you're doing more than that. And OSC may later assert that that's the case. And if that's what you're really certifying, that certification, we believe, becomes a lot more problematic. In part because, frankly, there are a lot of critical elements in an affirmative action plan that's more than a document. And y'all know this. Certainly as contractors, a lot of people don't even refer to it as an affirmative action plan. They refer to it as an affirmative action program. And that terminology is specific. It's supposed to be a living, breathing, active document, and that means there are activities that go on throughout the affirmative action plan year that doesn't necessarily have a certain ta-da, nick of time deadline. You're supposed to do it on a rolling basis in many respects. So when you're certifying that I have a, quote, true and accurate affirmative action plan and that I have, quote, developed the plan and am, quote, maintaining it, well, you're certifying it as of that date. And there are a lot of activities that may be ongoing that you, in fact, cannot certify to because you simply haven't gotten to it yet. Does that mean you're out of compliance? We would assert no. But that's the kind of problem that we're going to run into, I think, with this kind of language. Separate from that, I'm going to turn it back over to Bill to talk about some of the jurisdictional issues because you're not just certifying your, quote, planned existence, but you're also certifying this for particular entities. And that creates a host of other problems. So, Bill, back to you.
Thanks, Brian. Yeah, this enterprise is one of the few times in OFCCP's history that has done something that involves kind of determining something at the entirety of its jurisdiction. So it's trying to do this certification requirement over every possible entity that is covered by the affirmative action program requirements. And the only prior time, or one of the few prior times that has been attempted, was with the EO survey back in 2000. And I came in as deputy director of OFCCP in 2001, and we had this EO survey requirement that was imposed in regulations when OFCCP overhauled the affirmative action regulations in November of 2000 at the tail end of the Clinton administration. And so we came in, and one of the things we found with the EO survey, we commissioned a study by ABD Associates to study the efficacy of the EO survey, and that was the basis then for rulemaking to eliminate the survey as not being worth the burden. But one of the things we found that was challenging was it generated huge numbers of jurisdiction questions and controversies between entities that asserted they were not covered contractors and OFCCP. And part of this is driven by the fact that OFCCP takes a very broad view of its jurisdiction, and that view is often broader than what the actual legal requirements are and the legal standards for jurisdiction. OFCCP's general starting point is that once you have a covered federal contract, once a legal entity has a covered federal contract that triggers the affirmative action obligation, that extends to all the facilities, all the relevant establishments of that particular legal entity, but then issues come up with the way that OFCCP will start, as Brian mentioned, as the basis for determining who's subject to their jurisdiction as part of the starting point for the tool, the interface that they're creating, and who presumably they would send emails to, inviting them or asking them to go on and certify, verify their AAP status. That EO1 filing requires any majority-owned parent organization to file on behalf of all of its, majority-owned, a parent has to file on behalf of all of its majority-owned subsidiary entities, but the EO1 only has establishment reports, headquarters reports, and the overall consolidated report. There's no real basis or ability to file something that shows intermediate corporate entities So you could have a conglomerate or holding company that would be filing on behalf of numerous different subsidiaries, and really OFCCP, all they're seeing is a bunch of establishments and the ultimate parent. They're not seeing, that one is like a flight school, another is some other kind of entity. They're not seeing these intermediate corporate entities, and then they compound this problem with taking a very broad view of saying anybody who's related through that common parent ID to any other entity where they've checked the box on the EO1 form, that's the establishment form. There's a box on each establishment form that says, am I a federal contractor with, or federal prime contractor or first tier subcontractor with a contract of 50,000 or more, and I have 50 or more employees, and you check that box. And so OFCCP, once it finds that one entity in the under a parent chain has checked the box, then they assume all the rest are covered as well. And that's a bit broader, significantly broader than the legal standard for whether related entities, legal entities, might be subject to OFCCP's jurisdiction, which involves some very fact-intensive and complex legal standards, including the types of standards that are known as the single entity test. Some jurisdictions wouldn't even apply the single entity test. Some federal court jurisdictions would not apply that or would modify it in certain ways, but the historical regulatory standard that OFCCP has employed is the single entity test, that with these 5 factors, where basically factor 3, de facto exercise, meaning actual exercise of day-to-day control by one entity, one corporate entity over another, is the dominant factor within the test, but it's kind of like a balancing act between how some of the factors are more or less satisfied or not, and that involves very complex, fact-intensive determinations, and these are the kinds of things that certification obligation are going to evoke, because you have to make those decisions before you can know how you're going to respond to OFCCP emails, which OFCCP is going to be sending emails out to a much broader group of entities than actually are subject to its jurisdiction. The coverage for subcontractors is even more complex than the questions around related corporate entity jurisdiction, and they involve a host of fact-intensive issues, a host of unclear legal standards that might vary depending on the federal court jurisdiction of the employer. They involve questions of the relationship that very difficult to get information on. How is what you are doing in providing services or goods to a private business enterprise who has federal contracts? How is what you're doing related to their performance of their federal contracts? It has to be necessary to the performance. There's questions of timing. You're only covered when you're actually engaged in performance on the putative subcontract. You could only be covered in that regard if your performance is somehow aligned with whatever the prime contractors or more senior tier contractors' performance is. It's just a lot of very difficult questions on subcontractor jurisdiction that can emerge, and that is going to be something that is a predicate to knowing how to respond to this verification request. Many entities, when we did the EO survey, I think it was roughly between 25 to 30% of respondents said they were not subject to OFCCP's jurisdiction. So there were 50,000 EO surveys sent out, and about 17, maybe 15,000 of those came back saying we're not covered. So this is going to have a big impact on entities that are not subject to OFCCP's jurisdiction, where OFCCP is basically going to be sending out letters indicating that these entities have to respond and at least give some basis for not being subject to OFCCP's requirement. So this is what I talked about. This slide is the problem with starting with the EO1 reports as the base and then not really being able to see those intermediate corporate entities and really being very overbroad in who you're sending an email to, where you're probably sending it to thousands of entities that are not subject to OFCCP's jurisdiction. This is something that Brian and I do all the time, is help employers on OFCCP jurisdiction questions, and they're very complex. It can involve things like, what is the agency that you're contracting with? What is their particular statutory authority? I mean, for example, OFCCP attempted to assert jurisdiction in the Obama administration over healthcare providers, and that ended with some statutory provisions being added that make certain types of transactions that OFCCP was trying to assert jurisdiction over no longer susceptible to OFCCP jurisdiction. And there's other similar examples, myriad examples like that, many of which are obscure statutory provisions. And so it's not a question that stops with just looking at OFCCP regulations. That's kind of the beginning of the inquiry, and there's a host of other legal aspects of it that you have to track down before you can really answer those jurisdiction questions. I'll turn it over to Brian to talk about the certification, aspects of the certification tax itself.
Yeah, thank you, Bill. Some of you might be wondering on one of the earlier slides, why do we have a COVID virus icon on the slide about jurisdiction? And just so you know, when you're trying to explain it to other individuals within your organization, especially when you're thinking about the single entity test, and the way to conceptually think about it is, when an entity, a legal entity, engages in a contract, certainly that legal entity and all of its related sort of locations get covered by OFCCP jurisdiction, regardless of whether other locations are or are not doing work on that contract. That's how Executive Order 11246 works, Section 503 in VEVRA. Not the case necessarily with other federal contracting statutes, but at least with affirmative action, that's how it works. But under the single entity test, it's like a virus. Once it gets in your bloodstream, once it infects one legal entity, OSCP assumes that it goes upstream and downstream into the entire family and infects you all. And when they send out these single entity test sort of requests for information, they'll send you 40, 50, 60 request questionnaire that you're required to fill out, basically trying to show sort of how interconnected you are. But their starting point assumption is you are infected. And the burden is on you in many ways to sort of prove that you're not. And many times you can. But that is, as Bill said, that's something that you really do need to get ahead of time, especially before you certify. This is particularly the case because when you look at this user guide language, what you see now on your screen is a curveball that was added to the user guide that was just published. And it indicates the following. If you read it, it says, I certify that the information that's provided in our AAP certification is, quote, true and correct. Okay. To the best of my knowledge, I also understand that any attempt to refuse to submit an AAP certification, alteration or falsification of required records or information in any substantial or material violation may result in damages, etc. And here's another kicker. I also understand that I will not be able to edit my affirmative action plan after I click the submit button. There's a lot in that, I would assert. And frankly, there's so much in that, I wonder whether it's compliant. What I mean by this is well beyond anything that's in the current SAM system with respect to certification for bidders. It's also well beyond sort of the OFCCP regulations regarding sort of compliance status and what that means by regulation. It's also notably something that was not in the Paperwork Reduction Act notice and comment process. This is not something that OFCCP published earlier, and we all had a chance to make comments on and shoot at. That was not the case. So, Bill and I and other commentators sort of have been sort of scratching our head a little bit about this, in wondering, sort of, is this simply bad user guide drafting? And what we mean by that is that, the portal is supposed to be the portal not just for certification, but once it goes active, in theory, it'll be used for audits. And so when you're submitting confidential information to OFCCP regarding your affirmative action plan, your logs, records, other communications back and forth, supposedly a lot of this will be done increasingly through this portal, similar to what the EEOC has when they went electronic with their portal. And so maybe this is simply a certification that has to do with what you're submitting in the course of an audit. And if that's the case, then some of the certifications make more sense. But if that's not the case, and this is a certification that you're supposed to click with respect to just the verification itself, that's got issues, I think. And I think there's going to be a lot of challenges, frankly, about the scope of that. Either way, I think this is something that you probably need to talk to your counsel about when you're certifying, whether it's OSCP certifications or other sort of legal standards. There is a special defense available in the law related to the sort of good faith reliance on counsel defense when you're trying to certify that what you're doing is, quote, true, quote, and accurate to the best of your knowledge. That's something that we can certainly help you think through in advance, but you have to be careful about that. And Bill and I were actually having a discussion about this yesterday about some of the tricks that might come up with that. And Bill, do you want to add anything about this particular issue about advice and counsel?
Yeah, what the advice of counsel is also links in with the due process issues, right? So we talked about how this is a new vague requirement. In the public comments we submitted, we said there were these areas where it's very vague. Can you clarify? OFCCP refused to clarify, and so anything that it would later say in clarifying what's required to certify was never subject to notice and comment or the PRA requirements. And if they don't put out FAQs or something that tries to clarify later on, then obviously you don't have anything to go on in terms of interpreting some of these vague requirements. So the question then for good faith reliance and counsel defenses are within the scope that due process affords employers, which is very broad. Am I minimally compliant to the point where the certification is appropriate, given the lack of clarity on these points? It's not, and this is really important because it probably would work against the employer if counsel were to look at your overall compliance with all of the OFCCP requirements and say, well, wait a minute, you're not complying with these 5 items. As Brian said before, many of those affirmative action requirements are things that you implement and work on over time, and so you wouldn't necessarily have them completed at a given time when certification is required. So, but what you don't want is somebody looking at all your, looking at the full scope of the OFCCP affirmative action regulations and saying, did you do every single one of these? Have you completed all of those? And understand it as the predicate to being able to certify. That's not the right view. In fact, that's the opposite of the view that is the appropriate view under due process, which is the minimal, reasonable interpretation of the certification obligation, and what you need as a factual predicate for that is what governs whether or not it's appropriate to certify. That's the correct legal standard, not whether somebody has reviewed whether you're completely compliant with every single aspect of the OFCCP affirmative action program requirements, which involve all kinds of things involving implementing good faith efforts, pursuing action-oriented programs, all of these kinds of things that when you read the intent of the November 2000 OFCCP regulations, what they're intending to mean by having an affirmative action program, they say it's not supposed to be a paperwork exercise. It's supposed to be kind of a living management practice, and that's something that you can't certify at one given point in time. So I think you need to be careful about this review for purposes of validating that the certification is appropriate, and it should not be the kind of review where you're saying, are you doing every aspect, and have you completed all those aspects of the OFCCP regulations? That's not the scope of this certification. It's much narrower than that. Brian?
Yeah, perfect. Thanks, Bill. So yeah, it's complex, and this is just a warning. I mean, I think having counsel review this is a good idea, especially after we get more definitive sort of clarification about the scope. But there's a risk in sort of over-reviewing, and you definitely need to be sort of aware of that and give some good, cogent thought before you sort of wade into that morass, or in fact, it may affect your ability to properly certify. So let me go over a couple questions that we've got, some that we've sort of been getting over the last couple weeks that we're going to try and answer here, and then one that I saw online here. One question that somebody had asked is, are there any federal contractors who will not be subject to this verification requirement? And sort of like Bill and I said, the answer to that is yes. I mean, certainly you have to meet the AAP threshold requirement. You've got to, just because you're a federal contractor or subcontractor doesn't necessarily mean you have to do affirmative action plan. This is only for contractors who are covered not just by the base threshold for affirmative action, but by the AAP threshold. And likewise, as Bill mentioned, from the jurisdictional standpoint, you do have that single entity test issue for families of companies. A lot of employers, frankly, they're so integrated that they are going to be sort of integrated up and downstream as a federal contractor, and they're going to be subject to affirmative action plan jurisdiction. But that's not necessarily the case. And so that answer, am I covered, may not be as clear as you might think. The other question here is, that I've gotten a lot, I know Bill has, is what's the big deal about all this? Anyway, we do our affirmative action plans. We work on them every year. Yeah, we got to be careful about getting them done timely, but we do them anyhow, so why should I be concerned? So I'll take the first shot of that, and Bill can chime in on the next slide. So like we said before, you got to ask, so what are exactly the full obligations that I'm certifying? Is it that I've completed a document called an affirmative action plan? Is that I've complied with all sort of the requirements that go within it, that includes posting and outreach assessment and record keeping and certain notices and et cetera, et cetera. Does it mean more? I mean, that's a risky thing. And it's not just risky for purposes of an affirmative action plan. Keep in mind there are False Claims Act risks when you're certifying certain things to the federal government. I mean, you really are under penalty of law, not just audit law, but other law sort of taking a risk when you do that. And that does sort of present some liability exposure to you as an entity. Likewise, if you're a publicly traded company, you have other certifications that you need to make regarding, quote, legal compliance. and your certification with respect to this process now sort of gets elevated into that stratosphere. Likewise, like we mentioned before, there's a question about what contents are you certifying. I'm not a big fan of that language at the end that says, that you cannot, quote, in theory, change your affirmative action plan after your certification. Why is that? Well, certainly I would argue that the affirmative action plan is a living document, is not static. You're required to sort of have the core part of it during a given year, but a lot of contractors will update it from time to time as the years go along. And certainly when you get an audit, people will take a fresh look at that AAP and try and make sure it is as accurate and fulsome as possible before they submit it to the government. I think, frankly, that's allowed, in part because your affirmative action plan is allowed to be living, and that means it can live up until the last day I submit it to OFCCP, I would assert. But under this new system, if that other certification language remains, that can be certainly problematic, and we'll definitely need to pay attention to that. Bill, you want to talk about these next issues?
So I'm
sorry,
the
Bill.
issues on the same certification issue, Brian?
Yeah, about about how the OFCCP might use this information with respect to audit selection.
I mean, I think that there's some hope by the larger federal contractors that was perhaps expressed to some extent by the AP vendor comments that supported this system, that this would mean that the agency will divert its typical audit focus from known federal contractors who have large workplaces, which lend themselves to aggregate statistics that show statistical disparities in hiring and compensation, and away from that towards mid and smaller entities that might not be certifying compliance with these requirements. And so there is some hope that the agency would take some of its audit jurisdiction and refocus it on people that are not certifying, and that in turn will likely generate lots of jurisdiction disputes on single entity status, especially because OFCCP will be focused on those entities that it used the EO1 reports to start on. I would be surprised that any entity will certify that they don't, box number 2. I think because OFCCP really doesn't have jurisdiction to require an entity that it doesn't have jurisdiction over to do anything, including to certify that we're not a federal contractor. So if somebody gets an email saying, you should certify, and that entity thinks that there's no jurisdiction, I would expect that that entity would not certify number 2, which the number 2 option is, yes, I'm covered, but I didn't complete my required plan. So I don't think they're going to have a lot of that group. They're going to have all these email responses, letter responses to the email inquiry saying we're not a covered federal contractor. And that's what you got with the EO survey experience. And so they could divert some of their audit. They have capacity maybe to do 3,000, 4,000 audits a year. They could divert a portion of those to doing follow-ups on people that didn't certify. But I think the vast majority of those cases are either going to be primarily going to be entities that assert that there's no jurisdiction. That's the problem with part of this, the logic behind this, because it's basically saying, well, let's say there's a third-tier subcontractor who's a mid-sized entity that thinks maybe, yeah, I should be complying, but I just don't, and they just thwart the obligation altogether. What makes us think that they're going to voluntarily come and certify and tell OFCCP, oh, by the way, I'm not doing this? I mean, so there's a built-in oddity to the whole approach of capturing people that aren't complying, who just won't submit any certification whatsoever, and OFCCP is not going to have them on their radar screen necessarily and have any ability to divert their audit focus on those entities. So it's a question mark how this is ever going to be used for their audit jurisdiction, because it's either going to be somebody who's contesting jurisdiction. There's really not going to be, at least it's irrational for anybody to submit a certification saying, I didn't comply. So I don't know how there's going to be many of those entities to divert your audit attention to. Entities that do in good faith think that they are a third or fourth tier subcontractor may now certify for the first time, and that might now have those entities on OFCCP's radar screen, which they didn't even know were covered subcontractors before, and that could lead to audits being diverted to those kinds of entities, especially if some of those are larger employers. That would be somewhat surprising that there's many of those situations, but that could be something that emerges where OFCCP now has some information on lower tier subcontractors. And then, of course, OFCCP later on, as it gains experience with this certification requirement, could ultimately require annual filing of affirmative action programs. That would undoubtedly require full rulemaking to achieve that approach, but they could try to develop some kind of data system where, and that's a concern with the certification requirement, right, is this could now set the precedent for future years to lead to even more ambitious audit, kind of like almost annual audits of all federal contractors by coming up with some data application and some kind of data submission form that you have to submit that's broader than like the EO survey was, but is not as extensive as the full AAP. And so everybody's kind of subject to a statistical audit every year that's basically automated, and the government just has you upload it, and then the computer analyzes the data and they spit out some kind of response or some kind of a, use that to select people for audit. So this could be the first step in something that is even more problematic, and that's also a worry that people have with this. Brian?
Well, now you just scared everybody to death at the end of the presentation. So yeah, I mean that is sort of a brave new world, sort of the automated sort of AI sort of approach to audits. That would be terrifying. But let me just mention a couple of things. I know we're about out of time, and we want to be respectful of that. We know we've thrown a lot at you, but just a couple other quick questions. So I think we mentioned this question before: is the clock already ticking? We don't think so. For the reasons I sort of outlined earlier. You may hear some folks sort of jumping up and down about whether there's 90 days after OMB and whether you need to get ready to do that. I think you absolutely need to get ready, and to the extent that you don't have your AAP sort of in sort of good sort of form on a general basis, that's always good to do. But we think there's going to be an email notice and web posting system. We also think, frankly, they're going to wait for the new EEO1 data to come in. Otherwise, they're going to get a lot of garbage inputs, and I can't imagine they're going to be thrilled about that. Likewise, do we think there's going to be some challenges based on OFCCP's regulatory basis to do this? We'll have to see. It's interesting. There hasn't been as much chatter and pushback from the chamber and others on this as we might have thought. That may be simply because people haven't thought through fully the scope of what they're certifying. Likewise, we mentioned that some vendors actually are pretty keen on this because they think it's good work. We are not keen on this because we think it's good risk, and are not inclined to sort of throw our clients into that. But we are where we are. There may be some challenges, but we certainly haven't sort of seen anything get filed as of late. Which is interesting, too, when you think about OSP in general about this. I mean, the one big head scratcher is, okay, OMB dropped this on their sort of regulatory site through the sort of rulemaking process, and it was, published in the Federal Register the other week. But oddly, there's been no statement from OFCCP about this. There is no official press release. There's no grand trumpets from the pulpit. I mean, no one is screaming this. And it's interesting why. Bill, before we conclude, you want to opine about why you think they're quiet?
I just don't necessarily think that the political leadership in the Biden administration had this high on their list of priorities, and they're still trying to sort through how they want to use it and how it fits into that regulatory structure in terms of other things they want to prioritize and how they're going to implement it, what it's going to mean for their resources over the coming year.
Yeah, I mean, you're right. I mean, Bill and I were talking about this earlier. They have a limited budget, they have limited staff, and everything that gets added onto it is a diversion from that. And this is, Director Lean's baby, not the current directors. And so, it's something they are probably still in their own sense processing what they think about it and how they want to approach it. So hopefully we'll know more about that. If you have questions certainly about this later, feel free to contact Bill or myself. Our addresses are here on the deck. You'll also get an email later about this along with a copy of the deck, and you can pull that down. Certainly feel free to contact us at any time, whether we represent you or not. We'd certainly like to represent you, and we would like to help you. But certainly, even if we don't, we're glad to sort of chat with you and see if we can help you talk through issues as you try and navigate this internally. Likewise, speaking of navigating, tomorrow we're actually having a separate webinar on the fun new federal COVID-19 mandatory vaccination and testing requirements, some of which deal with large employers of 100 or more employees, but others of which touch on certain federal contractors and subcontractors, not all, but certain. And so we'll be doing a separate webinar at 1 o'clock Eastern Time on that topic, along with other publications that we've done on that issue. If you have not signed up for that or you need information on that, certainly contact us, but we love to have you. So thank you, everybody. Thank you, Bill, and we hope you have a great rest of the day.